Good evening, everybody. Thank you very much for coming here. Welcome you all to the seemingly last King's India Institute seminar for up until we head out to the assessment session. Today, we are here to discuss the topic or listen to a talk on the topic emerging legal and legislative frameworks around the LGBTQIA plus in India. And I'm Vignesh Karthik. I'm a PhD student at the King's India Institute. Today we have Manuraj Shanmugasundaram would be delivering the talk. But before that, I'd like to introduce the chair who would steer today's event, Dr. Mohsin Alam Bhatt, a very dear friend and a colleague. Dr. Mohsin Bhatt is a legal scholar based in Queen Mary University of London who focuses on constitutional law, minority rights, and law and politics. His research combines ethnographic and socio-legal methods in the study of the law. He is the co-founder of Parichay, a collaborative legal clinic that provides legal support to persons facing citizenship deprivation in India. He is also on the editorial board of Civil Liberties website, Article 14. Mohsin, over to you.
Thank you, Vignesh. It's really wonderful to be here back in the building. I think very much yours has spent 1 year of student COVID at the India Institute. It was not COVID, but really it's also an absolute pleasure to be meeting my recently in this conversation. On an extremely interesting and fascinating topic, and I think one of the particularly well-equipped person to talk about the emerging, many call it emerging legality around gender and sexuality. Now I'll come to some sort of framing in a bit. But let me first start with Manuraj. He is quite an eclectic achiever. He is a lawyer who practices in the Madras High Court, and he has in fact led some of the cases which I'm sure he will tell us about, which are relevant. He also is political actor in the street. Possible, he's close to DMK, still a spokesperson of the party. So that also gives him another background. And as it turns out, while I was doing my show research on him, he has done, before being a lawyer, he studied astrophysics, autism, something like this. So it's reasonably intimidating, and I'll be curious how all these different vantage points, brings them to the discussion with those really interesting issue. So just to give my own sort of sense of the questions, which I imagine Manuraj will be touching about, the first sort of aspect of the question of sexuality in general, when we sort of call it the new constitution around sexuality and gender. In fact, in many ways, my understanding, this is quite a recent, it's almost a decade ago. So in 2014, you have the Supreme Court announced a judgment, which was significant in a number of ways. And remember, 2014 for many of us seems in history. This is before Navtej Johar in 2018, which decriminalized homosexual sex. And I'll say in many ways was the first step towards Navtej Johar and subsequent jurisprudence. And this is the new constitutional jurisprudence that talks about autonomy, equality, dignity. And together, this sort of legal standpoint generates one range of important rights, which we'll be definitely talking about. But at the same time, there have been significant, while there have been steps forward, there have also been tremendous challenges. So when in 2019, the transgender bill happened, the big question around the bill was really one aspect of that, which is the question of recognition. And the trouble which many transgender friends colleagues had was how the 2019 fundamentally misrecognizes the question of gender by comedians, and that I think has remained sort of has continued to remain an embedded feature of how legality in India tends to think about gender and sexuality. So that's definitely one thing to be concerned about. Another thing perhaps to be concerned about, which I'm sure will come up again, is another facet of rights that was distribution of leadership. The question of reservation has been crucial. So 29 Act, for instance, the big system against it was that the Act did not provide for reservation, even though it now said that we did. And that is become another space for litigation. Again, I'm sure we'll be talking about that soon. Apart from the question of rights, both recognition and redistribution, I think there are three other themes which personally I would be very curious about. And that is really how the question of sexuality and gender in this field of new constitution, jurisprudence, and new constitutional rights has become a site of at least three. So the first is to become a site of ideological. The political parties are important players in this. Again, I'm really well pleased to tell us. The second is interinstitutional, of course, branch conversations, conflicts. So the Supreme Court, NALSA have laid down certain expectation, reservations, for instance, for 2019, did not provide for it. Now people have gone back to the Supreme Court. So there are these conversations that are happening among or between branches, which I think Manuraj is perfectly well placed to work with. He's not only participated in many of these battles, but I think he's also been a witness. Also because it appears to me, maybe you'll tell us more about it, how come Madras High Court has become the primary site in which many of these battles are happening. Most of this is happening primarily in Madras High Court, it seems to me. Also in Kerala, also in Karnataka, etc. Madras High Court seems to be the case. I don't know why that happened. Is it because of political reasons or otherwise? Something to think about. And finally, how this field has become a site for democratic politics. What has been the case of legal mobilization of, say, for instance, transgender communities? What has been the way in which courts have been turned into public spaces, public spheres, in testing rights? And what kind of directions is legal mobilization in this field? So with that, we will got trainings. I think hopefully I have done today. We can share straight over to the guidance of the so
let me begin by thanking firstly India Institute for providing this opportunity for me to be here with all of you. And secondly, let me thank Dr. Mohsin Alam Bhatt for that very detailed but succinct framing of complex issues. It's always easy to say complex issues in a complex manner. It's difficult to say complex issues in easy manner, and I think that's one of the excellent traits amongst many others of Dr. Bhatt. And thirdly, let me thank each and every one of you for coming here today. I know it's not easy. It's a Wednesday evening. It's after work hours. I understand from some of your colleagues that it is in the lead up to your own university assessment and other sort of tertiary education commitments. So I do appreciate all of you taking the time out to be here. I will try to keep this as short and succinct, and hopefully we will have an opportunity to discuss some of these issues. The reason for that is the reason why I chose this topic. I chose the word emerging as opposed to evolving. In fact, when Vignesh asked me to write down the topic, I wrote evolving first and then struck it down because I don't think it is evolving as much as, the word evolution conjures up aspects of finality and, us being at the top of an evolutionary pyramid. But in this particular case, much of the legal landscape or the trajectory is just emerging, and it is there for every one of you, whether you are a public policy practitioner, a political actor, a lawmaker, someone who's interested in legal work or academia, for you to sort of grab it, right? In many sense, it is a fairly, according to me, low-hanging fruit. It's something that we must have done many years ago, but better late than never, as they say. So here we are. Secondly, I think there is something very enriching about this field. You know, the LGBTQ legal legislative landscape is builds on the various successes we have had as a young constitutional democracy to show that how our constitution is still very much alive. It is very much expandable. It can take different shapes and forms, and it can fulfill the demands of modern constitutional democratic jurisprudences. So I think that has been a great sort of learning for me over the last couple of years, and I'll tell you a little bit more why. And finally, I think it is an enticing area because it is, like I said, rich in legal potential. It is rich in public policy potential, and it is something that I think is just waiting for people to get in and sort out. Before I go into my particular journey, my particular case that I worked on, which I will talk to you a little bit in detail over the second half of this talk. The first half, I want to talk about the sort of the judicial journey of LGBTQIA plus rights and jurisprudence over the last 15 or so years. I think it's important we understand where we came from and how much we have crossed to understand how much further we have to go. And in order to do that, I will just quickly, for those of you who are not familiar with either the Constitution or the Indian Penal Code, I will just go through a few of the relevant issues at the top so that we can go through the rest of the talk without me stopping and explaining that. So Section 377 of the Indian Penal Code was what came to be decriminalized by the Supreme Court in the Navtej Johar case in 2018. Talks about voluntary carnal intercourse against the order of nature. Just want you to remember these words because these words were ultimately what created the problem and then had to be resolved. With the Constitution, 4 articles are of particular relevance. Article 14, which is equality before law. Article 15, which is non-discrimination by the state. Article 19, which is the right to freedom, especially the freedom of speech and expression. And in the case of LGBTQ, the freedom to express one's sexual orientation or gender identity. And Article 21, the right to life, but in this case, the right to live with dignity and the right to privacy. These are the sort of the core, I guess, tools that one needs before you sort of get into the LGBTQ legal policy landscape. So on that note, the first case, I will go a little bit before 2014, because I think it's important to appreciate the challenges before we understand the successes. So the 2009 Delhi High Court judgment in Nas Foundation versus Government of NCT was the first, according to me, real sort of opportunity for a constitutional court to deal with sexual orientation. But it was limited, of course, as you all know, to the question of 377, Section 377 of the Indian Penal Code. And as you all know, the Delhi High Court held Section 377 to be unconstitutional and saying that it violated Articles 14, 15, 19, and 21. Specifically, the Nas Foundation case, the Delhi High Court said that discrimination cannot be permitted on grounds of sexual orientation. The reason the Delhi High Court came to this finding in one line is because Article 15 prohibits the state from discriminating against any citizen on the grounds of race, religion, place of birth, language, or sex. And the Delhi High Court did not limit its conceptual interpretation of sex to sex alone, but to include sexual orientation. So again, I am doing somewhat of a disservice by not going into these judgments in great detail. And that is disservice to the judges and the lawyers who argued these cases. But in the interest of time, I want to make sure we cover more ground. And in the first part of this talk, I will only talk about LGB rights or LGBTQIA plus. So everything but trans rights, because the trajectory of trans rights itself was separate, parallel, and completely independent of the other rights that we have now come to have classified under this umbrella of LGBTQIA plus. The progress of NAS Foundation case was undone not very long thereafter in 2013, when the NAS Foundation judgment was appealed before the Supreme Court in a case called Suresh Kaushal. A two-judge bench of the Supreme Court overturned the Delhi High Court judgment and the appeal and restored, in a sense, Section 377 of the Indian Penal Code back to the statutes. And in doing so, they held that LGBT persons constituted a minuscule minority. And secondly, they rejected the arguments placed on behalf of the NAS Foundation that there was a lot of harassment but from police, using this Section 377 as a tool of harassment, and said that that was not the intended consequence of the Section 377. So therefore, it was an unintended consequence, and you have remedy otherwise. And on these two grounds, again, I am sort of glazing over the judgment, but like I said, we have more to discuss. So on those basis, NAS Foundation was appealed and overturned. Now, before we go to Navtej in 2018, I want to briefly discuss two other cases because, as you know, though you have LGBT jurisprudence evolving through different cases, you must understand that a court as a whole is consistently evolving. The mindset of the court is consistently developing through not just LGBT cases, but other cases too. So the two cases which I feel contributed primarily to the change of the judicial mindset are, firstly, Justice Puttaswamy versus Union of India. The case was filed, it was a series of petitions filed to understand or to ask the court to decide whether the right to privacy is a constitutionally guaranteed right under Article 21, under the right to life article or not. I just want to quote two judges who wrote separate opinions, concurring but separate. One is the present Chief Justice of India, Justice Dr. D.Y. Chandrachud. And a lot of people, when this judgment first came out, they remembered the Chandrachud opinion mostly because he wrote about ADM Jabalpur case and said, it must be buried, 6 fathoms deep or something like that. And they contrasted it with his father's sort of judgment many, many years ago. But the interesting part is he also discusses Suresh Kaushal while looking at right to privacy. And while discussing Suresh Kaushal, the 2013 judgment, Dr. D.Y. Chandrachud says sexual orientation falls within the ambit of privacy, and he criticizes the principle of minimis, the fact that the earlier bench of the Supreme Court held that there was only a minuscule minority, so hence we need not, consider their constitutional rights. So he criticized that and stated that equality demands that sexual orientation of each individual, this is in my understanding of why he criticizes that, each individual in society must be protected on an even platform. Another judge, Justice Sanjay Kishan Kaul, former Chief Justice of the Madras High Court, he wrote a separate opinion. Again, not very widely reported because I think we were all overall happy with it. And when you're happy with the judgment, even as lawyers, we don't read it because we just want to know that, what we intended has happened. But Sanjay Kishan Kaul, who's now the number 2 judge in the Supreme Court today, so he states, in his opinion, that sexual orientation is undoubtedly an attribute of privacy. So your sexual orientation is something that is protected under Article 21. So this was two opinions written in the right to privacy judgment, less reported, less appreciated, but as you can appreciate here, the judicial mindset was already evolving, was already changing for the better. The other case, again, reported and understood for entirely different set of reasons is the cause title is Shaheen Jahan versus Ashokan. It is commonly known as the Hadia case. Many of you may remember, this is about a young woman who converted to Islam to marry a person, and then the case went up to the Supreme Court because the father, if I remember correctly, had filed a habeas corpus against the daughter and had raised a series of very communally problematic allegations against the whole process. But again, the Supreme Court held for all the right reasons that, and again, this was Dr. D.Y. Chandrachud in this judgment who wrote that choice of a partner within or outside marriage is within or exists within the exclusive domain of each individual. So you have the Supreme Court already saying that sexual orientation is an essential attribute of privacy and it's protected. And your choice of partner is also now protected under Article 21, and no one can actually question you as long as you're an adult of your choice of partner. Now, at that point of time, I remember when Navtej was about to be argued, I wrote a short opinion piece for an online publication called The Print. And I argued that this is actually now fait accompli, right? If my sexual orientation is protected by the Constitution, if my right to choose a partner is protected by the Constitution, decriminalization is done and dusted. But then so should be marriage. So should be, the choice of partnership between two persons, right? But what happened during the course of arguments in Navtej is that this union government took a position stating that if the court was to decide only on decriminalization, they would leave it to the wisdom of the court. Meaning, in lawyer words, in lawyer terms, that means we will not challenge it, we will not oppose it. We will go by whatever the court wants to decide. But if civil rights, marriage, succession, adoption, etc., were going to be argued, then the union government almost threatened, saying that we will file an additional affidavit, meaning they will fight it tooth and nail, right? And I'm using the word threaten very carefully because I saw it as a threat. Because nothing stops the government from filing an affidavit. I think nobody is not given a chance in a court of law from putting their arguments in paper, but it came across as a threat. Okay, and at that point, the court was put in a position where they made a decision that they will only decide on decriminalization, which is what I at that point argued was pointless because it was already, we had gone way past that. If you add Hadia case to Puttaswamy, we have already traversed the question, according to me, of marriage even. And at that point in my article for the Print, I estimated that if this opportunity was missed to discuss and deliberate on marriage and civil rights, we would have to wait another 7 to 8 years for another constitutional challenge to come. I'm happy to have been proved wrong because a series of marriage petitions are now pending before the Supreme Court. So it only took about 4.5, 5 years. But nevertheless, I still think that was time we could have spent doing something else. But I will not take away for a moment any part of the great leap forward for LGBTQ rights that Navtej Johar was and is, right? Because the Constitution bench of the Supreme Court not only held that 377 is unconstitutional as it infringes upon the rights, of autonomy, identity. They also said it does not create any intelligible differentia between what is natural and unnatural, which is, if you go back to the reading of 377, the whole impetus is on unnatural sex. So it reads that down. It also strikes down 377 for saying that it curbs the freedom of expression provided to every citizen under Article 19. And finally, it says that sexual orientation being an inherent part of self-identity means invalidating sexual orientation amounts to denial of right to life. So that really is where we have ended with regard to Navtej Johar and with regard to LGBTQIA plus rights. Now I'll stop there for one moment with regard to the LGBTQIA trajectory and pick up the trajectory of trans rights for one moment, because it has sort of had an entirely independent existence in some ways. And it is also very different because you will see when it comes to trans rights, states, the governments have been in fact more forthcoming in dealing with the issue, in offering policy solutions. In 2008, the Tamil Nadu budget that year allotted 50 lakh rupees to create a database of trans persons in the state, right? It was the first enumeration of trans persons in order to provide them with identity cards, so separate T identity cards. In 2008, later in 2008, early 2009, Tamil Nadu government set up a transgender welfare board with representatives from the trans community to advise government with regard to policy making for transgender. The government in 2008, April, the Tamil Nadu government also issued a government order providing affirmative action to public employment for transgender persons. So all of this had happened in 2008 and 9, just 5 years clear before the Supreme Court judgment in Nalsa. But again, like I said, I won't take anything away from Nalsa, but because it deep dives into trans rights like no other case before. And it dealt with the right of trans persons to identify as male, female, or transgender. It also looked at the transgender community and classified them as a separate class of persons who were socially and educationally backward, out of which comes the call for affirmative action and so on and so forth. And it really, I mean, for a Supreme Court to lay down all those sort of guidelines was indeed very progressive in 2014. Building on this, an interesting case in the Madras High Court again, in the Madurai bench, came up in 2018. The case was that a trans woman and a man went to get married in a temple in accordance with the Hindu customs. So they wanted to get married under the Hindu Marriage Act. When they went to register their marriage, the registrar said, I would like to, but I cannot. The reason being the Hindu Marriage Act statute specifically uses the word bride and husband. So he said that I cannot, interpret the word bride. So when this came up to the Madras High Court's Madurai bench in the case called Arun Kumar Shrija versus Inspector General 2018, the High Court directed that this marriage should be recognized and should be registered and interpreted the word bride to mean not only biological woman. It said it can also be a trans woman. And this built on the good sort of outcomes from the Nalsa judgment in 2014. But again, a very sort of small, innocuous judgment of about 10 pages. But till date, I have not seen any other judgment recognizing a transgender marriage in any other High Court or the Supreme Court. Of course, the Supreme Court is currently dealing with a batch of petitions which are now slated for middle of April, where a transgender marriage is also part of that. But again, this is something, according to me, was far-reaching. I at that time wrote for the Hindu on this, saying, welcoming this only so that more people would even hear about this. That a High Court judge sitting in a constitutional court is willing to interpret bride to say, not just a woman. And interestingly, this particular judgment has irked the union government no small deal. And in their counter affidavit, filed before the Supreme Court, first the Delhi High Court, and the batch of petitions were there, and now before the Supreme Court. They have particularly used these terms, saying that all the statutes are only between biological man and marriage between biological man and biological woman. So the Union government never had this particular terminology or jargon until this judgment came out. Now they have caught on to this and they want to overcome this. Again, very interesting, maybe too nuanced for the common sort of practitioner, but this is sort of what the present battle will be before the Supreme Court. But again, we're getting a little ahead of ourselves. I want to go back to Arun Kumar Srija, and after which in 2019, as Mohsin also mentioned, was the Transgender Act. Now, again, it has its problems, like all legislation must, and it must be allowed to sort of breathe and evolve and get better. But I think it is, I would still think it has a few positives. So for the first time under Section 3 of the Act, discrimination against transgender person is explicitly prohibited, right? Of course, the problem is that there's not enough, there is no penal consequence for it. So it is more of a sort of a wish list rather than a statutory provision. In sections 5 and 6, the entire recognition of a transgender identity is provided in the Act through a certification process through the district magistrate. Again, the problem is you have to go and sort of, I think, give your medical certificate, your sex reassignment sort of particulars and all of that. Whereas in other jurisdictions, now we are moving towards self-identification. So again, it has problems, but it is a start. There is also a constitution of a National Council for Transgender Persons to create policy making and to feed into the government mechanism. So these are some of the better aspects of the Transgender Act 2019, but this act is also pending a constitutional challenge before the Supreme Court. Now, that is sort of what sort of brings me to 2021, the early part of 2021, when I was asked to do a particular case, which has led to some positive outcomes and continues to do so. And partly I want to share some of my experience working on that case, only because I think it is important for us to understand from a practitioner perspective that a lot of these discussions are not purely academic alone. There is a huge academic importance, but how this plays out practically is what I think I want to sort of try and convey through the next 15 or 20 minutes. So the story goes back to sort of early March 2021. Two young women, they were 20 and 22 years at that point of time. They reached out to me through another lawyer and asking if they could come and meet. They had left their hometown of Madurai, which is about 400 kilometers from Chennai, where I live, and they had essentially fled from home because of opposition from their parents to their same-sex relationship. So when I spoke with them on the phone, I asked them if they could come and meet with me so I could sort of better understand and take down instructions. So as an aside, we meet clients day in and day out, and it's part of our job. But what struck me about these two clients was that they were young, obviously, and they come from a non sort of urban, metropolitan background, like Chennai, Bangalore, Delhi, Mumbai, Hyderabad, Kolkata. But also they've come from very, very modest means. They were poor. They were economically weak. One of their father was a watchman in a shop or outside a house. The other person's father ran a little shop. One of the issues, according to me, that Navtej had sort of unintentionally created was it suddenly seemed like they were elite, sort of urban, well-to-do people who are filing these petitions, demanding for LGBT rights. Now, I don't think that was the intention, and I think it would be unfair of me to be critical of it, but I think at that point, I mean, this is not as a lawyer, as someone just watching, reading society, suddenly you had five very powerful, influential, famous, persons in India filing this petition, which then became Navtej Johar batch. Right? So when I saw these people, I said, wow, this is an interesting sort of client, because now I can, if this case ever goes to court, I could sort of show the court that this is not a urban, Western, what is it called? Champagne liberal phenomenon, right? This is very much something that is very common. It can be, from any part of the country or any part of our society at large. Again, that's where sort of, I think as a lawyer, I was thinking, well, this is a really great way to sort of explain to a judge that this is not an elitist phenomenon. So they approached us to seek judicial sort of intervention because they felt like, they were still facing threats, even though they had come 400 kilometers to Chennai. And they kept saying, oh, we feel that somebody is watching us. It's like a sixth sense. We feel that our phone is being tapped or monitored, or we're not ready. So we filed a police representation. So what in India there is a provision to seek police protection. You can approach the court if there is threat to life and limb, and we first sent a representation to the police commissioner saying that, explaining the background. So remember, we left out their addresses because they didn't even want to share their addresses with us. So we put our office address saying they are now with us and we don't want to share their address. We send the representation. So usually from the time of representation, we advise clients to wait about 1 to 2 weeks before filing the petition, because the court needs to be convinced that the police have tried their best, right? And still we are not satisfied. So we did that, and while we were waiting, and we are about to file, or we had just filed the petition that day, and it takes another 4 or 5 days before a petition can come up for hearing. And during that time, I received a phone call from one of them, very short, abrupt call in the middle of the day saying that, they're taking us away, please come, please do something. And then the phone hung up. It is as dramatic as that. I then tried to call back. They wouldn't answer. The phone kept getting disconnected. Then somebody else answered and wouldn't tell me where they are or who the person was. So we had an idea of which suburb they were in Chennai, but I didn't have their address. But I hoped that whoever was taking them was sort of under the leadership of some police team, and that this can only happen. And if the police were to follow due procedure, they would necessarily have to take them to the closest police station first. So we went to the 2 closest police stations, me and my colleague, and they weren't there in the first, and they were luckily there in the second. Again, though we blame the police in India for many things, in this case, they actually followed procedure and it worked out to our advantage. So what had happened was, these women had left home very clearly, I think they'd left maybe a letter or something, but told their parents they don't want nothing to do with them. The parents went and filed individual FIRs in the police station, alleging that the women had gone missing. So alleging or insinuating that there was some trafficking or kidnapping. The kidnapping cannot happen, they're adults, but saying that the women have been sort of taken away, we do not know what has happened. So the police had actually come down from Madurai to Chennai to try and find these women, and the women were right. Their phone calls were being tapped. They were being sort of followed for a couple of days, and then they were located finally. So again, this is like a good place to stop and reflect, right? So we are 3 years after Navtej Johar in 2021, and I always try to understand, like the court says something, but then how has society understood it or interpreted it? Right? And again, this is not really taught in law schools, but when you have to go and deal with a police person, I always tell my colleagues, please assume they are 55 years old, male, and from a conservative background. Okay? Do not expect that they understand the nuances of any constitution bench judgment or any progressive sort of legislation. So again, like I said, it's a sort of thing where, as a lawyer, you also have to not just have the finesse of arguing before court, but if any of you are, I mean, part of our life is the unglamorous sort of arguing with police, right? Where it is just very uh, unrefined, one, to put it simply, but it's just, a lot of blaming, a lot of, the police at one stage saying that, well, if you are going to sort of, say this, then they are now your responsibility. And I said, well, they are 18 years. They cannot be my responsibility or anybody's responsibility. They are adults. But the police said, no, no. If we have to let them go from here, you have to sign an undertaking saying, I am taking custody of them. Ridiculous. No law would even permit that, right? It's simple. But that's the mindset. This is after like an hour of arguing with us, saying that, how can you do this? Look at their parents. Their mother is very unhappy. And then, the women facing a lot of sort of, luckily no physical harm, but a lot of psychological pressure of what is going to happen to your family. Your mother is not going to be able to step outside the house anymore, etc. etc. Remarkably, the two women, I mean, again, I say remarkably because they were so young, 20 and 22. I know how I was. They have really stood their ground amidst all this chaos, trauma, sort of badgering. They did not, I mean, because it took me about 3 hours to locate them. So while I was on my way, I kept thinking, if they give up, that's it, right? If they just say, okay, fine, we'll just go home. That's it. It's very difficult to get back, So that was, I mean, remarkable because these women just sort of stood their ground and until we reached there and whatnot. And again, as a lawyer, you think, okay, so you have your court, you have your police-related dramas, and now I've taken custody of these two women, right? Under whatever police law or understanding or morality. And now, this is where I think lawyers should also be smart human beings with a wide network in society. Because now I had this problem. They said to me they cannot go back home because where they had rented was A, compromise. Their families knew that. And B, the landlord, now there's like a police force coming in and breaking the door. So the landlord said, please don't come back ever. And two women, young women trying to find a house anywhere in the country or, anywhere in the world is difficult, has its challenges. These people were like, I can't go back. So we had to now find a place for them to stay again. Why is that important? Because that was now weighing on me. We'd already spent an entire half a day arguing with the police, getting them. The relief was short-lived because now I did not know where to, even house them for a night. And please remember, this was March 2021. COVID was very real. We were all wearing masks. We were all so worried to even walk into the police station because, it seemed like a bad idea with so many people in there. Again, what really helped was I had a contact, a friend who ran a shelter for women facing domestic violence, abuse, right, and interpersonal violence. I'd never heard of them taking any queer persons on board, but just decided to make a call, and she said absolutely. It was 11 or close to midnight, and she said, please bring them over. We'll make arrangements, and they stayed there for I think about 6 or 7 months, which really sort of took that burden off my head. Because suddenly I felt whether the police intended it to be or not responsible for these two women and their safety. Like usually, that's not the sort of emotional connect we have with clients, and I would not advise that either. But we sort of felt responsible what would happen to them. So which then allowed us to go and really sort of full-throatedly argue this case. Right? Again, interesting case. There are a few high courts prior to March 2021 which had allowed or ordered police protection for a same-sex couple, fearing threat and danger and apprehension of some threat, but not in the Madras High Court. So that was challenge number one. In the Madras High Court, on the other hand, they had given a lot of police protection orders to intercaste married couples, but heterosexual intercaste couples, which are again facing threats from family and so on. So the challenge for me was to explain to the judge that this is like an intercaste married couple, except they're not married and they're not heterosexual. So with this sort of, trepidation, but trying to sort of draw upon, these sort of ideas. On 22nd March 2021, we approached the court. We got the case for hearing, and the judge had no hesitation in granting police protection immediately. Said, yes, you made out a case, and from what you say, and I believe, the police have not done their job, and these threats are continuing. Please, I will order police protection right away. But the challenge was not just that. So then I said, well, but I think more needs to be done. And he said, why? And I said, well, I don't blame their parents. Right? I mean, I'm asking for protection of the women via the police from the parents. But I said, I don't blame their parents completely. Because I saw the father, or one of the fathers, and they were from a conservative, poor background. They would not know any better, to put it mildly. And I could see the concern in that father's face, whether justified or not is secondary, right? But I felt that concern was genuine. And now, given the sort of the trauma, the difficulty, the sort of the unpleasantness over the last few months, and especially that the day when they were sort of forcibly taken away, the women said, we will not speak to them. We won't even have SIM cards anymore because our parents will catch us and trouble us. And I thought that was also in some ways problematic. Again, not as a lawyer, but just as a person thinking that at some time, these women may want to reconcile with their families, like we all do, with friends or families. And I said, I don't think they should completely cut off, right? So that's it. What should happen? I said, I think the parents need to be counseled, because I don't think they understand what this is. And they think this is some sort of a affliction or a problem or a disease, or I don't know what, but whatever it is, we need to someone needs to sit and talk to them. So the judge said, great, this is, I think, a very interesting case. Yes, I will have an in-chambers hearing, and I will ask the parents to come, and you bring the petitioners, and we will talk to them. I will talk to them separately. I won't. So the 29th of March, so I say that because it's exactly 2 years today, we had an in-chambers hearing for almost 2.5 hours. Again, a typical hearing time for a case, like a police protection case, about 2 minutes in High Court. So at that point, I was extremely grateful that the judge had taken this time. He sat with the women separately. He spoke with them. Then he called me in, spoke with me, with them. Then he called the parents in. He tried to really understand what was the conflict here. Can it be resolved? What are the problems? And I think he understood, and I think we realized that the parents were really apprehensive that the women were moving further away. And we were able to say, look, we will make sure that you can have their phone number, but they will only call when they want to. But at the same time, you cannot, continue troubling them or harassing them or anything. So that was sort of the mediation, if you may, that took place on that day. But the judge agreed that, we need to sort of order maybe some sort of professional counseling. Again, this is where there's a little bit of misunderstanding. We got a queer affirmative counseling psychologist to talk to the parents separately about their fears, their concerns, their difficulties in understanding. But we also got them, the psychologist, to speak to the women. A lot of people said, well, why are you asking them to speak to the women? My justification for that was the women had gone through tremendous trauma over the last 3 or 4 weeks. They were on the run. They felt like they were being constantly chased, and they were looking over their shoulder every single minute. And that entire day in the police station, I think, left some fairly deep scars. So I wanted them to have a release, to be able to talk to someone. But we did not talk to them about their sexual orientation or anything. So this happened. There was a session with psychologists. We found a really good counseling psychologist, a queer affirmative counseling psychologist, who spoke to the parents separately, and then wrote a report to the court, which is like an expert report. And then when the judge read that, at that point, which was around the 28th of April, a month later, he indicated that he himself had certain prejudices. And I think this is now being widely reported because it is also in the order. So again, for a sitting High Court judge to sort of admit that he held some prejudices and he wanted to open and understand this issue better. So he, was sort of asked whether he could discuss some of his own prejudices with the counseling psychologist. So we had another round, another sitting where he did like a session, and he also, I think, reached out to a trans person, and then this is all there in the order where he says his own sort of journey and understanding. And I think he's very forthcoming in saying that he held deeply biased sort of notions around these issues. The one sort of useful contribution again that I felt I made here is that we argued that this judge now needed to issue some guidelines, right? And again, one of the sort of, I think, inherent problems we have with judiciary in India is that they love to write when it's not necessary, right? Like I think Navtej Johar is around 500 pages. Many other judgments which could, and I use this as an example because it's relevant to this talk, but also according to me, Navtej Johar is fait accompli. Meaning we had to, decriminalization was all but done. By then the government had conceded. Okay, but to write 500 pages, voluminous, I do not know how many people have even read it, fully. But on the other side, there is an innocuous para in Navtej Johar, which we found. Again, one of my friends, Arundhati who was one of the lead petitioner counsels in Navtej, as well as the same-sex marriage case now. She found, and then she, we were discussing that. Very innocuous para, I think, written by Justice Rohit and Nariman, if I'm not mistaken, where he sort of says, yes, it's all good, well and done, we've decriminalized, but the stigma continues, society will not change. So the state must issue guidelines, directions, and really, change this entire societal mindset and whatnot. And I think he meant more as a general sort of ventilation of his thoughts. But we use that paragraph to argue with the judge that the state also includes High Court, and a High Court judge sitting under Article 226 it's an extraordinary jurisdiction. It has very wide scope, and he can issue guidelines. So he said, well, are you sure? I said, yes, you can. So I showed him the paragraph. So then there was the 1 month court vacation in May, and in June 2021 is now like this very famous or well-reported order where he issues series of guidelines, and he talks about his own journey, but also says what is important. So I mean, just again to put it very simply, this the High Court Judge Anand Venkatesh, she also says that Article 15, though it only uses the word sex, it should be expanded to also understand sexual orientation and gender identity within that. So any discrimination on the basis of gender identity or sexual orientation is prohibited by the Constitution. Then he goes on to issue a series of guidelines. He so motu implemented 17 government departments and asked all of them to do certain things and what we to do. So since then, till date, this case is continuing. It's called a continuing mandamus, where government departments are now coming and reporting compliance with what they're doing. Now, I want to, as the last part of this component, I want to highlight the three, I think, key outcomes according to me over the last 2 years, right? Which, I mean, of course, there were the code guidelines, but now I'm telling you what the state has come back and said they have done. Firstly, again, the three key outcomes. The firstly pertains to the police in the state of Tamil Nadu. So the DGP filed, I think, multiple affidavits, but the Tamil Nadu police undertook a sensitization program for a lot of their, most of their police force across the state on LGBTQIA issues, just to sort of help them understand. They held sensitization programs, especially in 9 prisons in Tamil Nadu, and committed to the court that any person who identifies themselves as LGBTQIA+ will be provided separate facilities within the prison. And there was one of the concerns was male, men, women prison, right? But the most far-reaching commitment made by the Tamil Nadu police was in January 2022. They amended the police conduct rules to include any harassment allegation of against a police officer of harassment of a LGBTQIA+ person or an activist would amount to misconduct. So that would then go onto their service record, which no other state has done. Again, very interesting. This is the first time, according to me, any state government actually used the terminology LGBTQIA+. As you know, though it is, and this is the position of the union government today, though we have decriminalized, we have not recognized them. The very sort of nuanced and irritating argument, but that is what the government is very good at. So for the first time in January 2022, Tamil Nadu government amended the police conduct rules and for the first time used that terminology, which I thought was symbolically very important. The second department, which has really sort of gone out of their way to do a lot, is the National Medical Commission. National Medical Commission is the peak regulatory body for all medical professionals. So doctors are all governed by that. We pointed out that in much of their undergraduate and postgraduate curriculum, they had referred to lesbianism, transvestism, sodomy as either sexual offenses or as sexual perversion. And doctors, generations of doctors were being trained to think of it as such. And it's completely unscientific. So we asked them to do a complete revamp of their what they call competencies, which is their curriculum for undergraduate and postgraduate medical students. So they've done that, and they've removed all of these offending portions, which hopefully means that future doctors will not come with that sort of a training. The second part, which I think is the more significant or equally significant development, was we made a case for conversion practice or conversion therapy, as it's called, to be declared as a professional misconduct. So again, conversion therapy or conversion practice is not only done by doctors. The latest 2020 UN report says about 45% is done by doctors. The rest are done by religious leaders, quacks, spiritual gurus, etc. But we thought, this is a huge group which is regulated and we can do that. So the National Medical Commission put out a notification. And again, I don't know why, but only the Tamil Nadu State Medical Council has actually notified that, saying that any conversion practice or conversion therapy will be regarded as a professional misconduct to a doctor. So that was another significant sort of development. And the third pertains to the Tamil Nadu state government. We had talked about substantive legislative reforms and measures, but I also made a case that symbolism also matters in these cases. And we talked about, in one of the court hearings, we talked about how the language used in even media reporting was still fairly derogatory, and offensive and politically incorrect and morally wrong. So the judge said, but what can we do? Because this is a very delicate issue. There is a freedom of speech and expression in this country also. So we asked the Tamil Nadu government whether they would do what we now call a prescriptive media glossary of terms. So the government took up the challenge. They sat with experts in Tamil and English, and they've come up with almost like a 8-page document which has all the terms, everything from sex, gender, sexual orientation to gay, lesbian, pansexual, transgender, bias, every word under the umbrella, and given words which are correct, acceptable, and more importantly, inoffensive and not derogatory. And so now we've issued this to the media and said we hope that the media will now use these terms and report in a sensitive and respectful manner when you're reporting any issue. So I think very interesting, very subtle, but I thought a very sort of an interesting symbolic justice moment. The Tamil Nadu government has also, the education department has revamped its school education curriculum to bring in modules on transgender, sexual orientation, gender identity, and all of that, which is again good because now, as I think in year 6 and year 7, students will now learn about these aspects also in a proper manner. And also on top of that, this government has now started training teachers on sensitizing teachers who will now be teaching these subjects. And finally, the government of Tamil Nadu has worked on I think, according to me, the first state to put out a LGBTQIA plus policy. It is now under review. It's gone through a public consultation and it's now being reviewed in government, and hopefully that will be out. But there are about 6 states which have transgender policy, but nobody has a LGBTQIA policy. So again, that is something I think was a positive outcome from this particular case, a positive policy outcome. Now, the next short part, and I will end with that, is to try and understand what lies ahead, right? So just to recap, so we have the evolution of transgender rights from, like individual states like Tamil Nadu, Kerala, to NALSA and the Transgender Act, to the Arun Kumar Shrija judgment, which recognizes transgender marriage. We have now, LGBTQIA plus, which is, right from NAS Foundation, the decriminalization up to Navtej Johar, to the case that I worked on, Sushma Sinha, and so on, right? But it's around decriminalization and some ad hoc policy sort of responses. And of course, we have also the guidelines from the Sushma Sinha case, which sort of act as sort of general sort of policy motivation for the governments. Now, the next 3 big sort of areas which I see, going forward are, firstly, the batch of same-sex marriage cases which are pending before the Supreme Court. They're coming up for hearing next on 18th April. We already know the center has filed its counter affidavit opposing, but we hope that, considering it is before the Chief Justice of India, and he has specifically said he will constitute his constitution bench, a 5-judge bench for this, and that in the past, the judicial trajectory has been towards, expansion of LGBTQ rights. I do think that this is going in the right direction. But again, marriage aside, there are other sort of what I would call gender normative or heteronormative social security legislation. Now, these are the smaller things, right? Like these are in each of the different pension rules, right? Which are all very gender normative or heteronormative. So in most of the pension rules, is like the person working dies, the pension goes to the unmarried daughter or the unemployed son until they are 25 or something like that. Right? So there was a case before the Odisha High Court saying because there was a person who had a trans woman who would try to claim pension from her father's criminal benefits, but was denied that by the government because did not fall under the strict category of unemployed son or unmarried daughter. So these are areas where we are trying to now pull together different regulations. But as you can imagine, it's a mammoth, it's a Herculean task because there's just so many. Every government department, every public sector bank, every public sector unit has its own set of regulations. So it's not straightforward, but we're trying to pull it together to see whether we can do something to make it more equal. And then, of course, there are, assuming marriage comes through, there are questions of succession and adoption, which are also extremely biased. Now, if you take the adoption regulation of 2017, I think it says that you need to have established 2 years of stable marriage to be eligible for adoption. Again, marriage itself is not recognized what you do. And of course, Section 7 and 8 of the Hindu Adoption and Maintenance Act uses the word husband and wife. So these are all areas which need to be consequentially addressed after we overcome the same-sex marriage issue. So that is where we are now. That is where we are poised now. I just want to sort of conclude by saying a few different things, right? Firstly, my own sort of learnings around this, working in this area, is that I'm grateful that our constitution has that sort of flexibility it is expandable, it is not too rigid. Our judges have been forthcoming to interpret it in a modern, in a more humanitarian, in a more sort of liberal and contemporary sense. I do feel the problem, or largely, is now still how do we change societal mindset? It is one thing for a court to hold something, and of course that is the law now, and whoever it is has to follow that. But then society is still rife with unscientific information, pseudoscientific theories, disinformation. How do we change societal mindset, right? And that is where I think public policy plays an important role. That is where I think political actors have an important responsibility to take it to people. When death penalty was abolished in France, I think in 82 or 84, under Jacques Mitterrand, they actually, they abolished it overnight. And the next day, Le Monde carried a survey which said that I think close to 75 or 80% of the French population still supported the retention of death penalty. But I think, again, in times like these, it is when I think politicians also have to sort of swim across the tide, or people in leadership positions swim across the tide and use their political capital to convince people on issues that are of larger importance than just vote spinners. So I think that is there. I think we've still not understood some intersectionality issues. One of the issues you raised in your opening remarks about reservation for transgender persons. Now, you have a person who identifies themselves as a transgender, and there is also a caste component. So now, the Supreme Court in Nalsa has said they are socially and educationally backward. Which means they come under the vertical reservation category, right? So they have to be given the same treatment as a caste-based reservation category. Now, if a person in Tamil Nadu, there is a problem. The GO actually puts them in the backward class region because they're socially and educationally backward. Right? But if a person is both scheduled caste or scheduled caste, just giving you an illustration to explain the problem, and transgender, unfortunately, the automatic sort of they push into the most backward caste category in Tamil Nadu, as opposed to being a scheduled caste. So again, these sort of teething issues, problematic issues continue, but overall, considering sort of how the judicial response has been, the fact that in my own estimation, like I admitted, the Supreme Court has taken issues of LGBTQ importance 2 years before, I think, when they would have ultimately come to the Supreme Court. And they did that by transferring the petitions from the various high courts. So if it had gone through the regular High Court, Supreme Court process, it would have taken another 2 or 4 or 5 years. So by doing so, I think there is some light at the end of this rainbow, or a pot of gold at the end of this rainbow. And I think it is worth sort of people who are across public policy, legal, political domains sort of continuing to work on this, just because there is a lot of interesting areas of judicial and policy development. So I sort of want to stop there. I hope that I stopped on a positive note, but if not, I will try to make it more positive when we have a discussion. Is that okay? Absolutely. Yeah.
It was such a wonderful experience with you. I myself am one speaking for language as well. It was wonderful learning something, particularly the details of your own experience in the business. Before I say anything, we were actually meant to wrap up at 6:30. We started a bit late. If it's all right, and I think we're going to finish. We might take 10 minutes more and wrap it up. I think it's not long. It's what we're I was meant to give some sort of like remarks in response to what you've said, but in the interest of time, rather than giving remarks, I'll just I'll give context, and then depending on how people respond. I guess, let me just say two or three things. It was interesting that you were doing this, positive. I wanted to step back and make less optimistic points to start with, just to sort of explore and see what others say. So, for instance, in the first point, I was really taken by your initial distinction between evolving and emerging. You were right that what we see today in this new law and legal activity and litigation sounds less like evolving, it sounds more like emerging. And just to repeat, Anurag's point really was that to think of it as evolution, basically assuming you're going in one direction, it's better. But what also struck me was that you said that the court is always, and you used that word once. And what I suspect was that there was an underlying optimism about the legal system, particularly electors, in the way you present your story. And the reason I'm far less optimistic is, I reminded of a friend Gautam Gandhi once said while talking to colleagues in the LGBTQIA community, that for the longest time, sexual minorities were the subalterns. In many ways, that is not the case. In many ways, talking about sexual identity in Bhagwan Das Road, where Supreme Court says, is not stigmatized for a variety of very good reasons. But I feel that whole range of other issues have increasingly come. So I'll give you two contrasting examples. Just when D.Y. Chandrachud and other judges were saying wonderful things about trans rights and LGBTQIA rights, there was another judge sitting, placing bureaucracies of National Register of Citizens. And when Swati Barua, prominent trans activist from Assam, went to the Supreme Court saying that trans people have been excluded from the citizenship registration, you were basically asked to do the court. And there was absolutely no resistance. Just when Chandrachud and other esteemed colleagues are giving wonderful opinions from Navtej all the way down, the same Supreme Court has watered down the atrocity exam and has in many ways created problems like that. So Hadia case is a good point in a story which is horrendous started out. So my worry is that focusing perhaps too much on optimism, what we have seen, perhaps overestimates the mitigating effect of what we see here in other places. Just when you look around the rest of the legal system and the jurisprudence of rights, either of caste or religion or women deciding to convert and marry anybody else they want, notice the irony. The woman can't convert in order to marry, but the woman can transition and marry, which is great. But there seems to be a dissonance in our legal system, and we need to acknowledge that. Now, to what extent, what does that do to our assessment? And optimism is perhaps all of us to think about it and lots of other details. The second sort of point was, which is wonderful, and it really came out well in Maharaj's presentation. He really talked about the legal genealogy for gay lesbian rights, for men who have sex with men, men who want to get married to men, women who want to get married to women, on one hand, and the legal genealogy of trans rights. And they were different. But just wanted to sort of place it on the table that there are also whole range of social genealogies very much. So the litigation before NAS emerged out of struggles which were shared by trans people and gay lesbian communities. And that significantly, there are stories that are really joined at the table and belong to society. Also, another interesting thing, important thing Maharaj talked about was in your litigation, you are going to talk about caste. How you try to make a caste analogy. And caste analogy is another way to sort of think about how struggles about caste stigma or gender stigma, whole ranges of alternate groups, all these battles are really joined together. And that I think was a significant thing I want to highlight in what we are saying. And just one final thing, another really interesting thing in Mandavi's presentation was how social action litigation, as she said, often becomes a site of transformation. And in this litigation which you talked about, there are multiple transformations. As the judges, I think I noted one name with Venkatesh. He says that I am going through a transition of my moral perceptions of sexuality. Clearly, the state is going through transformation. And that's, I think what I wanted to say was both the positive side of it, but perhaps what I was worried about, maybe you could talk about either now or subsequently, get an outcome of your own, is what happened to the public. My worry, perhaps always in these kind of sort of high profile litigations, that while everybody else is transforming, the judge is seeing his own moral transformation in the story, the lawyers are active, the police department is wearing a cap and a category. We tend to forget the people who are the victims of the system, who should be at the center of our story, not marginal story. So when, for instance, please look at the media coverage of this particular case, your case, really important case. I'm just obviously you're nitpicking and trying to see the darker side of the story. Almost all newspapers cover how the judge is the protagonist, transforming, evolving the state from the civilization. I found almost no stories of that. Perhaps it's a good thing, maybe they didn't want to be. But immediately I was worried that in this severe male complex, you all know what that looks like, trying to transform the state, the communities who are the center of violence may get marginalized. We have seen part of that even in the 377 petition. For those people who are interested, we want to go back and talk to others, and now stuff has been written on how people were deeply critical of Supreme Court litigation because communities were marginalized and certain lawyers or certain protagonists took over, whereas the reality of the issue changed or not much. So what I would be again curious to know is, where is the community in these transformations? It's fine, you have Honorable Justice Navtej bringing about, ordering consultations and therapy, etc. But is that marginalizing the community? Is the community a participant, an equal participant, all the time they participate in this transformation? And where are the organizations, the people who work in these kinds of I don't know about this, but I was just so on those three really slightly darker works. Just want to put any of both of them. There was some more works. So I'll stop here.